everyone, and welcome back to the channel, Shelly's Millions. I want to talk to those of you who are working in the state of California or are an employer in the state of California, especially if you're in the HR Human Resources Department. We all know that unfortunately cases are on the rise right now, and that means that as an employer, you might be asking your employees to quarantine. If you received a notice that you were in close contact with someone who tested positive for COVID-19, it's possible that your company will need to exclude you from the workplace. And if they ask you to stay home from work, you want to know, are you going to get paid for it? And do you need to use your own personal sick time to stay at home? What many employers don't realize here in the state of California is that while the COVID-19 supplemental sick pay ended and expired on September 30th of 2021, OSHA actually mandates that employers pay their employees something called exclusion pay if the exposure occurred in the workplace. The reason why I wanted to share this today is I think a lot of employers are having trouble staying on top of what's required and what's available for their employees. It changes really rapidly, and it's different from city to city and state to state and county to county, but this is for all of California. So it's really important, and I even have tips for you at the end of the video on how to talk to your employer about it if you think that you are eligible for exclusion pay. Facts on exclusion pay under the Emergency Temporary Standard. OSHA's Emergency Temporary Standard, ETS, on COVID-19 prevention require employers to exclude employees from the workplace under certain circumstances. While the employee is excluded, their employer must maintain their pay and benefits. For more information on the ETS and whether it applies to your workplace, refer to OSHA's frequently asked questions. If an employee is excluded from work because of workplace exposure under the ETS, is the employee eligible for exclusion pay? Yes, an employee who was excluded from work because of a workplace COVID-19 exposure should receive exclusion pay. If the employee was not assigned to telework during that time, I know a lot of you are already working from home. This would not apply to you. It also wouldn't apply if your employer is allowing you to work from home after the exposure. Condition 2, the employee did not receive disability payments or workers' compensation, temporary disability payments during the exclusion period. How does Labor Code Section 248.2, the 2021 COVID-19 Supplemental Paid Sick Leave Law, interact with the ETS? I'm not going to read this because the two programs aren't interacting with each other anymore. The extra supplemental paid sick leave for COVID-19, that was no longer available after September 30th of 2021. And I think that's what more employers are familiar with, and that's why they might be telling you that there's no COVID sick pay available anymore, because they were very aware of the supplemental paid sick leave for COVID, but they're not as familiar with this exclusion pay. But since the two programs aren't interacting, I'm going to go ahead and skip down to this next question. Can employers require employees who are excluded due to workplace exposure take paid sick leave under the ETS? Employers that provide a paid leave policy that is separate and, in addition to the paid sick leave policy required by California's Paid Sick Leave Law, Labor Code Section 246, may require their employees to use that separate sick leave as permitted by law. Most employers, though, guys, do not provide additional sick pay on top of the sick pay that is mandated under Labor Code 246. I don't like to say this, but most employers are going to give you the bare minimum sick pay that they're required to by law. But if for some reason your employer offers you extra sick pay on top of the sick pay that is required by law, then you might not be eligible for exclusion pay. It also says an employer may require an employee to use any supplemental leave available to the employee under the 2021 COVID-19. But again, that did expire September 30th, so that's not in play anymore. However, an employer cannot require the employee to use the standard paid sick leave mandated under Labor Code Section 246, even when there has been a workplace exposure and the employer is required to exclude employees under the ETS. How long does an employee with COVID-19 exposure or who test positive for COVID-19 from the workplace receive pay while excluded from the workplace? An employee would typically receive pay for the period the employee is excluded, which could be 10 or more days. If an employee is out of work for more than a standard exclusion period based on a single exposure or positive test, but still does not meet the regulations requirements to return to work, the employee may be entitled to other benefits such as temporary disability, disability, or supplemental paid sick leave. What rights do employees have if their employer retaliates against them for requesting exclusion pay? Employees are protected under various California statutes prohibiting retaliation for exercising workplace rights. Employees should seek assistance from the Labor Commissioner's office if they have questions about retaliation or want to file a retaliation complaint. Does an employer have to maintain an employee's earnings and benefits under Section 3205C9C if the employee is unable to work because of reasons other than COVID-19 exposure at work? No, the employer need not maintain the exposed employee's earnings and benefits if the excluded employee is unable to work because of reasons other than exposure to COVID-19. Like a non-work exposure, a business closure, caring for family members, disability, or vacation. Such employees may be eligible for other leave, including sick leave or other benefits such as disability, paid family leave, or unemployment benefits. The ETS states that an employer is not required to provide exclusion pay if the employer can demonstrate that the employee's close contact was not work-related. What does that mean? The ETS doesn't require employers to pay you if you're excluded from work if the employer, your boss, your job, can show that your exposure was not work-related. In such circumstances, employers may have other legal or contractual payment obligations, but pay and benefits are not mandated by Section 3205. How does an employer show that a COVID-19 exposure is not work-related? Proving that COVID-19 exposure is not work-related to avoid the ETS exclusion pay requirement involves the employer conducting an investigation and producing evidence to show it is more likely than not that an employee's COVID-19 exposure did not occur in the workplace. So the burden to show that you didn't get COVID in the workplace falls on your employer. How is exclusion pay calculated for employees excluded from the workplace due to exposure to COVID-19 at work? The rate of pay for exclusion pay is an employee's regular rate of pay for the pay period in which the employee is excluded. These employees are entitled to exclusion pay depending on the length of the required exclusion period and how many days they were scheduled to work during that exclusion period. Employees must be paid no later than the regular payday for the pay periods in which the employee is excluded. So, for example, if you are someone who's normally scheduled 3 8-hour shifts a week, which would total 24 hours a week, and you go to your first shift, so you work 8 hours, then your employer should pay you the additional 16 hours of exclusion pay for that week if your employer is the one who asked you to stay home because you were exposed in the workplace. Can OSHA enforce the exclusion pay provision? As with any violation, OSHA has the authority to issue a citation and require abatement for violations of OSHA standards. If an employee is excluded from work because of workplace exposure under the ETS and is not paid, where can the employee file a claim? If the employee did not receive pay for the exclusion period, the employee can file a claim with the Labor Commissioner's Office. The Labor Commissioner's Office can accept claims only for those employees who have been excluded from the workplace due to exposure at work. What if an employer does not exclude an employee from the workplace who was exposed to COVID-19? The ETS requires them to exclude workers who had close contact to persons with COVID-19. Now, close contact is going to be if you spent more than 15 minutes cumulatively in a 24-hour period in close contact, meaning 6 feet or less, with someone who tested positive. That's going to be what defines close contact. If an employer has improperly failed to exclude employees under the ETS, employees should contact OSHA, file a workplace safety complaint. For more information, see OSHA's COVID-19 guidance and resources. And sometimes, guys, your employer is not going to have to exclude you from work depending on if you're symptomatic and your vaccination status. How can an employee file a claim for exclusion pay with the Labor Commissioner's Office? The employee may file an individual wage claim for exclusion pay with the Labor Commissioner's Office. Alternatively, the employee may file a report of labor law violation, RLLV, with the Labor Commissioner's Office. A RLLV is a claim that alleges a systemic violation of law that affects several individuals. The Labor Commissioner's Office, in such a case, would evaluate whether the report involved the whole workforce and whether the Labor Commissioner's Office bring claims on behalf of the entire workforce or direct employees to file individual claims. Can employees qualify for workers' compensation if they were exposed to COVID-19 in the workplace and test positive or are unable to work due to COVID-19 related symptoms? Employees who test positive for COVID-19 or are unable to work due to COVID-19 and believe they contracted COVID-19 at work should consider filing a workers' compensation claim with their employer. For more information, see the Division of Workers' Compensation COVID-19 guidance and resources. Employees who have received disability payments or are covered by workers' compensation and received temporary disability payments are not eligible for exclusion pay. So if you're already covered by one program, then you wouldn't be covered by this program. What pay or benefits may an employee be entitled to if they were exposed to COVID-19 outside of the workplace? Employees may be entitled to other pay and benefits. Please see additional resources on various programs administered by the Labor Commissioner's Office and other government agencies. I was getting a lot of comments that many employers aren't telling their employees when someone has tested positive in the workplace, and that is because people's individual medical records are protected. So your employer doesn't have to tell you if someone tested positive in the workplace. A lot of you are saying a lot of people are going on vacation, and that is to protect your medical records. Now, they should be informing you if you were in close contact with someone who tested positive for COVID-19. And again, close contact is defined as more than 15 minutes cumulatively in a 24-hour period with less than 6 feet of distance separating you and your coworker. your employer still wouldn't be able to tell you who you were in close contact with that tested positive. They should just send you an email or call you or otherwise notify you that you were in close contact with someone who tested positive for the COVID-19 virus, and that would be sufficient for them to notify you. If your employer hasn't told you about exclusion pay, I know that that might be frustrating. That might seem like they're trying to do something shady. I like to believe in most cases that is not what's going on. I think a lot of employers just don't know about this. I think a lot of heads of HR departments are trying to stay on top of all this. The information is different from state to state. It's different from county to county. It's different from city to city. So it's possible that they just don't know, and that's why I made this video. Again, my sources are linked in the description down below. If your employer has told you that you need to use your own personal sick pay for this, what I would recommend doing is the following. I would recommend emailing your boss or your HR department, and I would just say, hey, I did some research online. I found the below information on the california.gov website. I found another news article published by a law firm, and it seems to say that I might be eligible for something called exclusion pay. Would you be able to look into that and get back to me on if I'm eligible for that? And then once you've sent your employer those links from the government website and from the law firm, hopefully that gives them the tools and resources that they need to research if that applies in your situation or not. All right, guys, I hope this video was helpful. Thank you so much for watching Shelly's Millions. I'll see you next time.